Hey everyone, my name is Chris Chuff. I'm a partner in Troutman Pepper's business litigation group. I specialize in complex corporate and commercial litigation, particularly in the Delaware Court of Chancery. I'm joined today by Taylor Bartholomew, an M&A and corporate attorney from Troutman Pepper. Taylor, who also sits in Delaware, represents clients in a wide variety of public and private transactions, including, as relevant today, private equity deals. He also specializes in counseling clients in matters of Delaware corporate governance law. So we wanted to take a few minutes today to discuss a few drafting issues that we've seen crop up in connection with operating agreements of PE portfolio companies. And then in a separate podcast, we're also going to address drafting considerations in PE acquisition agreements. But today, we're going to focus on the operating agreements of portfolio companies. And on the operating agreement side, we're going to discuss fiduciary duty waivers, exculpatory provisions, indemnification provisions, and the possible unintended consequences of those provisions. So welcome, Taylor.
Hey, Chris. Thanks for doing this and thanks for having me.
So let's start off with fiduciary duty waivers in PE operating agreements. I guess first, when should a party be negotiating for these waivers?
So I think parties should be seeking to negotiate fiduciary duty waivers whenever possible, assuming that the party is the private equity firm. So when we are on the buy side of private equity transactions, one of the first things I think about when I'm drafting an LLC agreement for a platform deal is how do we want to think about fiduciary duties, right? Do we want fiduciary duties? That's not to say that fiduciary duties aren't useful, and I'll get to that in a second. But really, private equity firms need to be concerned with having their designees on the board or their designees in officer positions at the holdco or the opcos following closing. They need to be concerned with these folks having fiduciary duties. That's not to say that fiduciary duties don't keep people honest. They very much do, and we do think about those things in these types of deals, except as you and I have talked about plenty of times in the past, a lot of the big Court of Chancery cases coming out these days actually deal with private equity firms and their designees getting into hot water because they may have made a decision that is able to be second guessed by a minority member or equity holder of some type, usually rollover members. So when I'm on the buy side of a private equity platform, the acquisition, when I'm thinking about fiduciary duty waivers, I say, hey guys, it's great to be honest, right? It's great to have fiduciary duties, but may not be the best thing if you guys don't want to be second guessed. So on the private equity side, I would say those folks should be negotiating for fiduciary duty waivers. On the sell side, I would say if I'm representing a rollover investor, right, someone who's selling their business to private equity, I would try to the extent possible to get some kind of fiduciary duties out of the private equity firm and the designees. Why? That gives me more of a voice as a minority investor. Whereas if I had a full-blown fiduciary duty waiver, I couldn't challenge anything based upon the duty of care. I couldn't challenge anything importantly based upon the duty of loyalty, any kind of conflict transaction, right? So if I'm a minority investor, I like to think of fiduciary duties as a minority protection, especially in the private equity realm.
So basically, when you're on the PE side, you should always be negotiating for these waivers. But when you're a minority investor, you want to try your hardest to negotiate for the inclusion of either full-fledged fiduciary duties or at least some contractual standard of conduct that keeps the board of managers in check, right?
Exactly. And that's not to say that it's binary, right? It's not necessarily the case that it's you either have a full-blown fiduciary duty waiver or you have full-blown fiduciary duties, right? So I've seen it on the ground level where PE firms will agree to, for example, I have fiduciary duties except in the sale context, right? Or on the flip side, I have fiduciary duties in the sale context, right? Except in limited circumstances, right? So you can get pretty creative with these things because, as everyone who's listening to this hopefully knows, LLCs and LPs, right? Those are creatures of contract under Delaware law. So we can really get pretty creative with when fiduciary duties apply, when they don't apply. It's not a one-size-fits-all approach. And a lot of the times it really does boil down to negotiating leverage, right? How badly does the private equity firm want this portfolio company, right? How badly does it want to acquire this target? Is it an important issue for the sell side, right? Is sell side thinking about it in the same way that I just described it?
Got it. Okay, now assuming though that the deal that's reached is that we're going to have a full disclaimer of all fiduciary duties, how should such a waiver be drafted in a portfolio company's operating agreement?
That is a great question. My take on it is simple as best. We want one or two sentences at most for it to be effective. And I think too often I see especially with form documents, right, which is a major pitfall in actual practice. Too often do we see that these form documents have, sentences upon sentences about the fiduciary duty waiver and carve outs and whether they are intended or not intended. Ultimately, I think a lot of practitioners are just sort of skipping the page when they get to the fiduciary duty waiver and just say, hey, that's been in the form for so long, right? I don't need to read that or think about it. But, there has been some recent case law that has shed some light on pitfalls and not thinking about that through more clearly.
Yeah, exactly. There's been some recent Delaware case law that has actually shown that, the longer a waiver is, the more likely it is for a court to find a potential for that provision being regarded as ambiguous, which is going to allow a fiduciary duty claim to at least surpass the motion to dismiss, which means there's going to be discovery, there's going to be depositions, there's going to be doc production. And that's exactly what a fiduciary duty waiver is trying to avoid, is trying to provide complete clarity that there are no such claims so that you don't have to deal with the litigation. And I agree wholeheartedly that, the best waiver, I think, is just a sentence that says fiduciary duties of any, members, managers, officers, et cetera, are hereby waived. That does it. You don't need to say any more.
That's exactly right. And I like to think about that too, as I always break it down into a couple of elements, right? So it's, first of all, what fiduciary duties apply, if any, right? And then who should get the benefit of that waiver. So to your point, Chris, it's the members, the managers, the officers, right? Is it all of these folks and
right.
these entities? And then do they get the full benefit of the fiduciary duty waiver to the fullest extent by law? Right. And if it is a full-blown fiduciary duty waiver, that's a sentence. It shouldn't be more than one sentence. And any more than a sentence just sort of, it could make it ambiguous, because the court can say, well, why did the parties put all this additional language at the end of it? Why is there another 3 sentences, right? What's all this talk about, gross negligence, willful misconduct, good faith, all this sort of stuff?
Yeah, exactly. Yeah, I agree. And that actually, there's another aspect of this that could also affect the impact of a fiduciary duty waiver, which kind of leads to my next question, which is, what is the interplay between fiduciary duty waivers and exculpatory provisions? And can the drafting of one of those provisions impact the effectiveness of the other?
Absolutely. It's an interesting question. And I think each case that deals with it just gets more clear with each passing case. I think the interplay is really stated simply. You can revive fiduciary duties simply by saying, that a fiduciary will not be exculpated for acts done with gross negligence, willful misconduct, or good faith. And on the, by the same token, by including that kind of a carve out in the fiduciary duty waiver, you can have the same effect.
Right.
So one can impact the other, in other words, and revive fiduciary duties, notwithstanding the fact that you have included in your waiver or exculpatory provision language intending there to be no fiduciary duties.
Right. So we've seen a lot of agreements that say, first, there's in one section says there's no fiduciary duties. But then in another section, it says, managers shall not be personally liable for monetary damages, except in the case of gross negligence, willful misconduct, or bad faith. And what the Delaware courts have said is that those concepts, gross negligence, willful misconduct, and good faith, are akin to and the equivalent of the fiduciary duties of care and loyalty. And so, you have one provision that's supposed to completely get rid of these duties, and then another provision that is saying essentially that a manager can be liable for monetary damages for the breach of duty of care and loyalty, and therefore reviving the very duties that they were trying to get rid of, usually earlier in the contract. And so is the takeaway there that for a PE-backed fund, PE-backed company, that they should avoid carve-outs altogether, or if not avoid them, limit them significantly?
That's exactly the takeaway. I mean, my first approach is, of course, to include a full-blown waiver of fiduciary duties, right? Full stop, no exceptions. And then once we get the inevitable markup back from someone who is up to date on the law in Delaware that has all these carve-outs, right? Or maybe it's just opposing counsel that says, hey, I have seen this gross negligence, willful misconduct, and good faith language in every forum that I've dealt with in the past 10 years. What gives? Why would you delete this, right? Or why shouldn't we insert this? Then I try to have a conversation about, well, this is a PE-backed company, right? We're all in this together. Economically, we all want the same result, which is to get a great exit, right? With a lot of return on investment. So, let's try to do this together and just sort of preserve the fact that we're not going to have these fiduciary duties where you can second guess the decision of the PE firm ultimately at the top. So I always start there. And then if sell side counsel says, hey, I think we should keep willful misconduct or good faith because we think loyalty, right, it should be the line, then that's really a conversation I try to have with my client to say, look, that means your fiduciary duty of loyalty kicks in. That means we need to be more wary of conflict transactions. That means we need to be a little more tight when we're doing things in the ordinary course.
Got it. So basically, if we're representing PE company, we want to either avoid the carve-outs and the exculpatory provisions altogether, but at the very least, if we're going to have carve-outs, we want to get rid of the gross negligence carve-out, because what we're doing is we're reviving care claims, which creates the possibility for second guessing of management. Exactly.
And I would even argue that if we're representing PE firms, right, because it is so often the case that in a buyout situation, the PE designees will control the board entirely. We want to get rid of that duty of loyalty. So if you wanted to offer some kind of counterpoint, right, if you wanted to accommodate the sell side with something other than a full-scale fiduciary duty waiver, you could do what we talked about before, right, which is to have context-specific fiduciary duties. So I only have fiduciary duties in the sale context, or I don't have fiduciary duties in the sale context, but the ordinary course I do, right? You can come up with these creative accommodations to make sure that you're not hampering the business in the ordinary course with these, equitable safeguards, but you're still giving the other side something that they may want.
Got it. Okay. All right. So bottom line there is that you want to be very careful that you're not kind of reviving and reinvigorating potential loyalty and care claims that you were trying to get rid of in the fiduciary duty waiver. Now, does the same risk and consideration pose itself with carve-outs to indemnification provisions in the operating agreement?
So I'm not aware of any cases that actually address whether including those terms in an indemnification agreement would revive fiduciary duties. But after analyzing the cases that are out there that hold that those terms revive fiduciary duties in the exculpatory provision or the fiduciary duty waiver, ultimately, I'm left with the impression that the court would not say that claims are, or that those terms would revive fiduciary duties in the indemnification context. So what I always try to advise our clients is it's purely a business decision as to whether you actually want to indemnify managers, officers, members for conduct that amounts to gross negligence, willful misconduct, or bad faith. A lot of the times that is where PE firms will draw the line and say, well, you may not have fiduciary duties for those things, but we're certainly not going to indemnify you for those things.
Yeah, that's my read of the case law as well, that basically, an exculpatory provision addresses the circumstances in which a manager may be held liable, and therefore it makes sense that carve-outs to those provisions have the effect potentially to, reinstitute or revive fiduciary duties. Whereas indemnification, as you said, is just here are the circumstances in which I'm going to provide managers with indemnification or advancement, and that it wouldn't make sense that carve-outs to those provisions would revive duties. It's just these are the circumstances in which indemnification is going to be provided. So that's my read of the case law as well.
And really, at the end of the day, that could be used as a bargaining chip too, to say, look, we don't want fiduciary duties, but the way that we keep these folks honest is to say, you may not have duties, but we're not going to pay you if you do these things, right? You're going to be on your own dime.
Yeah, I like that. All right. Thanks again, Taylor. That's all the time we have today to talk about the drafting issues regarding operating agreements of private equity portfolio companies. Tune in next time where we're going to talk about specific drafting issues in PE acquisition agreements, including various provisions addressing fraud.
Copyright Troutman Pepper Hamilton Sanders, LLP. These recorded materials are designed for educational purposes only. This podcast is not legal advice and does not create an attorney-client relationship. The views and opinions expressed in this podcast are solely those of the individual participants. Troutman Pepper does not make any representations or warranties, express or implied, regarding the contents of this podcast. Information on previous case results does not guarantee a similar future result. Users of this podcast may save and use the podcast only for personal or other non-commercial educational purposes. No other use, including, without limitation, reproduction, retransmission, or editing of this podcast may be made without the prior written permission of Troutman Pepper. If you have any questions, please contact us at troutman.com.